Good morning. Are you Matthew Wadsworth?
Yes, ma'am.
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from this one.
All right, Mr. Rojas,
The courtroom opens quietly, but tension is already in the air. Matthew Wadsworth stands before the judge, facing aggravated assault with a deadly weapon. The deal on the table? A cap of 8 years in prison. The judge seems polite, but you can sense it. She's already unimpressed.
you may proceed.
Yeah, Judge, the cap of 8, the agreement, I think, is a cap of 8, and just based on the criminal history alone and the PSI, it looks like
It looks like you did a very good job of getting that agreement.
that's kind of what, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, Judge, there are some things I'd like to point out. If you look at, I'm not talking about his felony criminal history. The first page of his, I guess, rolling into this second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2001. In January of 2002, they all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them.
The prosecutor starts painting a picture that's hard to ignore. A criminal history stretching back to 2002. One charge after another, all stacked up like a bad habit that never ends. He even admits Matthew's lawyer did a good job getting such a soft deal. A rare compliment in this courtroom. But you can already tell, this isn't going to end with sympathy.
Got some more in October 2002. Then after that, he goes in. Basically, he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case,
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safe PD to help with his drug issues. He understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he pointed out by the probation officer in the report, he's indicated then that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change.
Now Matthew's defense pivots. They blame mental health and medication issues. His lawyer argues that he only gets in trouble when he's off his meds. It's the classic I need help, not punishment defense. And to be fair, Matthew says he's tired of being in handcuffs. He claims he's ready to change. But is that enough after years of chaos?
He does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
I only wrote this because I get really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. Oh no. Basically, listen, man. I was a bad kid until I was ADD poster child. I was put on Ritalin. Then I did really good. The Ritalin, I went from straight ups, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin. I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. I hope it don't hurt me, but I got beat up. I had a robbery in 1992. When I got out from that robbery until
2.
when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids.
Matthew reads from a letter, trembling, nervous, and brutally honest. He admits to being a drug addict, talks about a childhood filled with abuse and neglect, and blames his downfall on mental illness and trauma. It's raw and painful, but the courtroom has heard it all before. Still, there's something haunting in his words. A man who knows he's broken, but can't seem to fix himself.
If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on. But in my head, our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it. My truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. When we started fighting, I was losing. And I said, if you do give me the chance, what I need is some help staying on my meds. Because I start feeling like I'm doing better sometimes. And then I stopped taking them. When I stopped taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Wadsworth,
Matthew explains how everything spiraled out of control. His house burned down, his medications were destroyed, and his mind started playing tricks on him. He insists he didn't hit his roommate with a bat, just his walking cane. But when someone's record looks like his, small details stop mattering. You can feel the judge's patience thinning. She's heard enough excuses for one career.
here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Okay.
The problem is you're 51 now, 52?
51. ma'am.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said this.
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors, 21 felony convictions, 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of and in addition to the 21 and the one pending, you have 16 others that were dismissed because of.
The judge finally steps in, firm, calm, but unyielding. She tells him point blank, "You've had opportunities. You know you need your meds. But at some point, society can't take that risk anymore." Then comes the hammer blow. "You have the worst criminal history I've ever seen." Pause there. 39 misdemeanors, 21 felonies, and one pending case. That's not just a bad record. That's a lifetime of destruction.
Plea agreements, and things like that. So that's 38 felonies. The last, and I get a lot of this was from 2002, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017. So not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr. Smith.
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony. 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's pending. Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account of probation where he said the part about the baseball bat is not true. A dresser fell on top of him.
I saw that.
He's still not accepting responsibility.
I hit him with the cane.
Hold on, don't
I'm
speak
sorry.
over. I let you talk.
Even as the judge lists his endless charges, from escape to obstruction, unauthorized vehicle use, and more, Matthew tries to defend himself, but it's over. The prosecutor cuts in, pointing out that even now, Matthew can't take full responsibility for his actions. And that's the moment the courtroom mood shifts completely. From sympathy to finality. Everyone knows what's coming next.
So don't talk over anyone else, please.
I believe probation is absolutely right, that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8 years TDC.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement. Because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir.
The judge delivers her decision, 8 years in prison. She even admits she almost rejected the deal, calling it ridiculous given his record. But justice is served within the limits of the law. Her parting words cut deep. There's help in prison. It's up to you whether you change your life or not. The bailiff takes him away. Another man swallowed by his past. Final thoughts. This case reminds us, no matter how many chances life gives you, at some point, the law stops believing in change. CTA. What do you think? Was 8 years too light or fair? Drop your opinion in the comments, and don't forget to like, share, and subscribe for more real courtroom moments just like this.
Go back with the bailiff.